Member Port of Spain North, St. Anne's West.
Thank you very much, Madam Speaker. Madam Speaker, it's quite unfortunate that my friends on the other side aren't here, because it was quite an important proposition that I'm about to make, but I will start anyway. Madam Speaker, I'd like to start at the outset by congratulating the Honourable Attorney General and all those who worked with him to be able to bring this modernizing piece of legislation to the Parliament. Because for those of us who have practiced in the arena of law, and in particular in the commercial realm in litigation, would have been very familiar with the unfortunate difficulties that we would have encountered over time dealing with the quite archaic Arbitration Act that applied before. And just for those who would be following, the members of the public, to let them know through you, Madam Speaker, that arbitration has a very important role to play in the world of commerce and in commercial entities and how they resolve their disputes, etc. But also for the government. The government enters into many contractual arrangements over time. And if I may recount one of the experiences I've had in litigation, and it was with respect to the National Oncology Center that the government had tried to construct many decades ago. And it eventually ran into problems with the Canadian entity that was to build it, etc. And it was subject to arbitration. So you had the government of Trinidad and Tobago in arbitration with arms of the Canadian government, etc. The arbitration was carried out in Miami. And it is a perfect example of how arbitration can work. Because what you were able to do is you had a single arbitrator. There was very limited room and recourse for appeal. The parties sat down and basically with experts went through the whole arbitration proceeding. Now, there are a number of differences, and it dawned on me, I was listening to some of the previous speakers. One of the things you give up by going for arbitration is you're going to have to incur the cost of arbitration. So I just want to put that there. And the cost of arbitration would differ because, of course, we don't have a cost of paying judges in the judiciary ourselves, apart from through taxation. But litigants don't pay judges to hear their case. In arbitration, of course, you must pay the arbitrator. And as the bill provides for, it can be up to 3 arbitrators. One of the points that was made by my friend from Mayaro, and it requires correcting because unfortunately it is from a script of the opposition where they're constantly trying to peddle information in the public that there has been no foreign direct investment in the country and no money is being spent in the country and nobody wants to invest their foreign exchange in the country. Just to give one example that is irrefutable, during the period of 2017 to 2021, in the upstream alone in energy sector, in gas, so this is the upstream producers in our gas sector in Trinidad and Tobago, for the period 2017 to 2021, $9.2 billion US dollars, which is 62.5 billion TT dollars, have been spent in upstream, and that is direct foreign investment. So to continuously hear from the member of Mayaro, as he likes to peddle here and elsewhere, that there's no foreign investment taking place, that is only in the gas upstream investment to keep the gas production going. 62.5 billion TT dollars, 9.2 billion US dollars. That does not include, of course, all of the investments that have gone on in our petchem industries and other industries. So just to put that to rest and to alleviate any concern that the population may have had listening to the unfortunate peddling of misinformation sometimes by those on the other side, there is a host of foreign direct investment taking place in Trinidad and Tobago. When you look at a project like Manatee to come on stream, we're looking at about $1 billion to $1.5 billion US dollars. Now, to deal with the issue I wanted to come with, and is very, very relevant, the previous speaker for Chaguanas West touched on it, and that's the issue of confidentiality. And why there's a need on occasions, because I accept the proposition that there are times when, with arbitrations, where the state is involved, either as the Office of the Attorney General or state entities and state enterprises, state companies that have undergone arbitration. Maybe sometimes it should be made public, and that's why the bill provides for in the public interest. But just to put on record for persons to understand, there are many instances, in particular in the energy industry, where this should not happen and cannot happen. For example, when you have a state entity that is contracting with a number, let's use NGC as an unfair example, contracting with a number of different petchem companies, meaning ammonia companies, methanol companies, etc. And if they get into disputes and they go to arbitration, as has happened, this is a live example, the period of 2010 to 2015 left the NGC with $9 billion in claims. Some of those had to go to arbitration. Very often in those contractual arrangements, you would enter into different pricing arrangements. So if Chaguanas West is getting a certain price and a certain structure of their deal for the provision of gas, Barataria Sawa may be getting a different price and different deal and structure. And one of the difficulties you have when you're operating in a complex, sophisticated commercial environment like the energy sector, and in particular the gas industry, you would not want the type of information as to what Chaguanas West is getting versus what Sawa Barataria are getting. And if that goes to arbitration, and both of you all have me in arbitration, for example, you would not want it to be made public if there's an award made with respect to Chaguanas West that then gets and falls into the hands of Barataria. So I just want to put on the record, and it's an appropriate time, to sensitize the population. It is not that the government has anything to hide, or any state entity in those instances have anything to hide from the public or from the public interest. In fact, what you're doing is you're protecting the public interest, because you see the global energy sector operates with a certain accepted level of confidentiality. The deal that BP may give to the government is going to be a different deal to the deal that Shell gives to the government and EOG gives to the government. And they operate on the understanding that their trade secrets and how they structure things will be kept confidential, because if it gets into a competitor's hands, of course, it eradicates immediately the competitiveness. And of course, that applies to arbitration proceedings. So just to put on record, because very often you hear it being proffered that there's secrets and that the state is hiding something, or the state enterprise. In particular, in the energy sector, it is a very, very sensitive sector. It is something where we're competing globally. So right now you have these companies taking decisions in their boardrooms, many thousands of miles away, in a boardroom in England, in London, or a boardroom in The Hague, in Holland, and they're deciding, where do I spend my capital expenditure? And if we in Trinidad and Tobago expose ourselves, so they say, well, I can't go and do business in Trinidad and Tobago anymore, because of course it's confidential. A deal they may do with us here, they may not do in Indonesia, they may not do in Africa, they may not do in other jurisdictions. So to sensitize, the population to those instances where it is absolutely essential that we together, meaning the population of Trinidad and Tobago, protect our industry by not saying, well, produce it for the population, produce it for the public. Because, for example, the deal that we're able to negotiate on pricing of gas with one of our upstream gas suppliers who also operates in other jurisdictions, they would not want those other jurisdictions the same way I don't know what is the price of gas they're getting in Norway or in the North Sea in the UK or in Sierra Leone, etc. So we must continue to protect those instances. As I was saying at the outset, I would like to commend the Honorable Attorney General and all those who worked on this piece of legislation. It was high time that we modernized the legislation, and you can see it immediately as you start to look through it. We have taken the approach of accepting the UNICITRAL model law, and anybody who has participated in international arbitrations would know that one of the accepted models is the UNICITRAL model. And in fact, I heard my colleague, the member for Diego Martin Northeast, talking about rules and whether rules would apply for arbitration. Of course, the parent legislation does not set out the particular rules of procedure, but again, to alleviate any concern, whilst the Parent Act does set out the need for statements of case and exchange of evidence, etc., the rules would be determined by the parties to the arbitration, as happens all of the time. Very often you would accept the unicitral rules of procedure, and that is what would dictate. They can have case management conferences. It's up to the arbitrator and the parties to decide these things. And in fact, that would be prudent in the management of arbitration. And my colleague for Diego Martin Northeast is very familiar, not only from an academic point of view with arbitrations, but also in advising on arbitrations. I recall previously when he was a client, not personally as a member of previous government, etc., and having to take instructions. But it was always difficult for him to take advice. I'll put that on the record. But when he would take the advice and when we would be participating and preparing for arbitrations with some of the previous hats that he wore.
You followed instructions.
I wouldn't give that story here. I'll put it on the record. That is true. I heard our friends on the other side teasing my colleague as he stood in the box, and I was remarking to them, but there's no need to tease him, because from the time he changed lawyers, we won the case all the way up to the Privy Council. This piece of legislation that is before us, whilst it does oust the court's jurisdiction in certain instances, I think we have gotten the balance correct here, with specific and express provisions that protect the safeguards, and you see it throughout the bill. If I may just quickly turn to quite an interesting one, which is at clause 2, subclause 2.6, where they say, this act shall be interpreted and administered in accordance with the following principles. A, subject to the observance of the safeguards that are necessary in the public interest, the parties to a dispute should be free to agree on how the dispute should be resolved. It is very reassuring to see that type of provision as an express provision in the legislation, because it's setting at the outset how the arbitration should be conducted. In other words, one of the key principles of arbitration, parties should be allowed to decide how they're going to deal with the dispute in front of them and how the dispute should be resolved. B sets out and limits the intervention of the court save for specific circumstances. 6b says the court shall not interfere in the arbitration of a dispute except as expressly provided in this act. And then, interestingly, at C, where the court interferes in the arbitration pursuant to the express provisions of this act, so it is immediately ring-fencing the authority of the court to intervene, and this is the principle to be applied, it shall, as far as possible, give due regard to the wishes of the parties and the provisions of the arbitration agreement. So at the outset, you see them setting the foundation upon which arbitration should be applied. I just wanted to quickly and briefly turn to clause 5 of the Act. The objects of this Act are two, and they set out the objects of the Act: to facilitate domestic and international trade and commerce by encouraging the use of arbitration as a method of resolving disputes. B, to facilitate and obtain the fair and speedy resolution of disputes by arbitration without unnecessary delay or expense. C, to facilitate the use of arbitration agreements in domestic and international matters. D, to facilitate the recognition and enforcement of arbitral awards. And E, to adopt the unicitral model law. So we reinforce that there. It also modernizes and accepts, unlike the previous act that it's replacing, that we are now in an age of use of electronic communication. So we set that out at clause 6, subsection 2, unless otherwise agreed by the parties, and electric communication is be taken as received. And it is good to see, as we are already in that electronic age, now our legislation is evolving and accepting that these are acceptable modes of communicating, and we set out. Talks about the waiver of the right to object, which is necessary in arbitration. Two of the things that you need, especially in commercial arbitration, is certainty as to how it is going to be dealt with, and finality. Finality meaning that you can't just run when a decision goes against you by the arbitrator to court and delay the arbitration proceedings. I think the Act gets it right and sets out very limited circumstances when you can appeal, in inverted commas, to a court. The previous legislation, the law had grown in that area that really sometimes frustrated the hearing of arbitrations. So you see here at Section 8, Clause 8, in matters governed by this Act, a court shall not intervene except as provided by this Act. So at the outset, they're setting the stage, and it's a general ouster provision. And then it goes on to set out through the rest of the Act the instances that you are allowed to have a court intervene. You see at Clause 11, the arbitration agreement and substantive claim before the court. And this is done exactly to provide certainty and also permits the arbitration to proceed even though issues are before the court. And this is a very forward-thinking provision that says even if you have issues before the court in limited circumstances, whilst the court is determining it, for example, the parties agree on a very limited issue to go before the court, the arbitral proceedings may nevertheless be commenced or continued. An award may be made while the issue is pending before the court. So you see, what you're telling the commercial world is you don't have to be subject to the delays of the court, but you can really proceed and have flow while something is being looked at by the court. I think my previous speakers, some of them who spoke, talked about the interim measures. We talk about the court's involvement when you can't decide an arbitrator. That is normal in these types of matters. Talks about the grounds to challenge an arbitrator. And interestingly, at Clause 15.3, it says, subject to subsection 4, an arbitrator may be challenged only if A, circumstances exist that give rise to justifiable doubts as to his impartiality or independence, or B, he does not possess the qualifications agreed to by the parties. This provision is meant to limit some of the challenges you've seen in the past where one of the parties is seeking to delay the arbitration proceedings by challenging the appointment of the arbitrator and is limiting it in that way. And then subsection 4 says a party may challenge an arbitrator appointed by him or in whose appointment he has participated only for the reasons of which he became aware after the appointment was made. So sometimes, as you're proceeding in the arbitration, you didn't challenge the arbitrator, but something comes up later on that gives you cause for concern, and you're allowed to challenge the arbitrator at that stage. Essential for arbitrations, especially of international natures or in commercial arbitrations, is Clause 19.1. An arbitral tribunal may rule on its own jurisdiction, including any objections with respect to the existence or validity of the arbitration agreement. Previously, there was a body of law that questioned whether the right forum to challenge jurisdiction was the arbitrator or you should go to court. This is saying, look, in the first instance, the arbitrators themselves can determine whether they have jurisdiction or not. And then it goes on at 19.9 to provide a level of protection that permits the court still to have oversight on arguments of jurisdiction. But it also provides, as I said, that finality because there is no appeal of the court. So at 19.9, it says, where the arbitral tribunal rules on a plea as a preliminary question that it has jurisdiction, any party may within 30 days after having received notice of that ruling request the court to decide the matter, and the decision of the court shall not be subject to appeal. So in other words, you could go to a court at first instance, they will determine whether they got the jurisdictional point correct or not, and you can't go any further. It talks about the interim measures. I think we've heard about that. My friend from Chaguanas West quite rightly pointed out what it's meant to capture, which are injunctive relief, things like, well, we used to call them Mariva injunctions and Anton Pillar orders. I know the law moved away from that, and it's freezing orders and international freezing orders, and this is all done to protect the assets. So, for example, in an OAS type situation where you didn't want assets being dispersed and dispensed with before you had a chance to get the fruits of your award. So, Madam Speaker, I didn't want to take up too much time. I think it is a good piece of legislation. I commend it. And as I say, it is something I fully support, having been a litigator for many years, seeing the immediate benefits of what this piece of legislation provides for, especially in the realm of commercial certainty and parties deciding in commercial instances that they want to go down the road of arbitration as opposed to court proceedings. And the main point I wanted to make, I made, and is worth repeating and concluding with, is there are many instances, especially in Trinidad and Tobago, in particular in the energy sector, that we have to protect confidentiality. So this conversation that is taking place, that you must expose everything in public interest, I just caution us on that, because if we begin doing that, it is going to take away some of the little competitive advantage we have globally in that very sophisticated sector. I think I've given sufficient examples which would apply to arbitration proceedings. So, Madam Speaker, with those few words, I thank you for the opportunity to have contributed and just to put those few points on the record.
Member for San Fernando West.
Madam Speaker, I propose to be very short in my contribution on this bill. I'd like to say that I join in celebrating the arrival of this bill. I had the pleasure of supervising the original work beginning in 2018, 2019, 2020, 2021, and I would like, for the record, to thank publicly the members of the several entities who have spent dedicated time in ensuring this happened. That's the Trinidad and Tobago chapter of Chartered Arbitrators, ATIC, the Ministry of Trade and Industry, the Judiciary, the Trinidad Chamber, the Office of the DPP, the Bankers Association, the FIU, the Legal Aid Authority, the Trinidad and Tobago Police Service, the Trinidad and Tobago Center for International Arbitrators. In particular, I'd like, for the record, having spent a few years well engaging with two people, I'd like to put them onto record, Mr. Dennis Gurley, Senior Counsel, and Ms. Salma Rahman. These two individuals spent dedicated hours, energy, and effort in producing the drafts before us, which had several iterations. I'd also like to publicly compliment the judiciary of Trinidad and Tobago for ensuring in the open consultative process that a lot of this was to put on record in the right form. Now, Madam Speaker, the Honourable Attorney General speaks not only with passion, but with great experience in this area. And I'd like to say that this bill represents for us a few things that are of worth in connecting the DOT-STAR system. First of all, the bill in producing a modernization of the arbitration law takes us away from the 1939 perspective, when the world was just about to go into World War II, when the Franco War the Spanish War was being won by Franco, when industrialization was at the point. Minister Imbert, Minister of Finance, gave us the mercantile history and background. But I'd like to say, Madam Speaker, that this law really brings us into modern session, and it adds to our civil justice system. Minister Young put onto the record the objects which are contained in the bill at Clause 5. And in looking at the fact that the Clause 2 of the bill centers with arbitration grounded in the matrix of confidential information with the use of electronic submissions and management, capturing both domestic and international arbitration, Madam Speaker, specifically saying that an aim and objective is to bring UNCITRAL into effect. I'd like to say that what this bill does in bringing forward not only UNCITRAL, but with a dedicated marriage to the Impact Justice Model Bill of 2022, is that it brings to life a very important feature which our Prime Minister has championed for Trinidad and Tobago, and that is the Caribbean single economy perspective, the single market perspective, as we head into the celebration of CARICOM, the Treaty of Chaguaramas, this month of July, Madam Speaker, I want to remind that the CSME and the integration of our economies finds itself in the matrix of this bill. Because this bill recognizes that the law of contract can prevail. This law recognizes that transaction contracts and evidence of arbitration agreement in a series of agreements can bring to life an arbitration position. This law, in creating with the Treaty of Chaguaramas as basis, with Trinidad and Tobago where it is, this law fits into the vision of this government. It's why we moved the civil courts to Tower D. It's why the civil courts don't occupy all the floors, because it allows, Madam Speaker, for the utilization of arbitration in Trinidad and Tobago, not only in the local commercial arena, but in the CARICOM arena, which fits into the international perspective. So, Madam Speaker, I dare say that this bill, Clause 5, its objects to facilitate the use of arbitration in domestic and international matters, to facilitate and obtain fair and speedy resolution, to facilitate domestic and international trade. I want to plug the fact that we're looking at regional trade as well. Madam Speaker, I spent a lot of time in commercial law, and in commercial law and in joint venture agreements and in structures. The point in commercial business law is to win the war, not the battles. It's the overall outcome that matters. It's the dominance of the marketplace. This bill underwrites a more prosperous Trinidad and Tobago, a commercialization of our sector. It takes into effect, Madam Speaker, that most of our judges, prior to us raising the age of retirement to 70, would in fact retire at 65 and then serve in other jurisdictions. This law allows us to broaden from the civil proceedings rules, from the alternative dispute resolution mechanisms contained in the overriding objective and in the specifics of the civil proceedings rules. It ties into this law that arbitration can be done by way of election. Now, what is beautiful about it, and Minister Young touched upon it, is the fact that costs are to be factored. Yes, there'll be a cost for the arbitrator per se, but I do believe that by adopting the formula for the once in 360 days exception if it's under 30 days for tax-free status, as the British Virgin Islands and as Jamaica does, and as the UNCITRAL CARICOM model in its position does, allows us to provide an invitation to come and do business into Trinidad and Tobago. Madam Speaker, I'll turn quickly to the issue of confidentiality to just give a small perspective on that I think is relevant. I'd like to remind, in answer to Chaguanas West, that we are not proposing by clauses 58, 59, 60 that the arbitral proceeding shall be private per se. There is an exception, Madam Speaker. If you look to clause 60, the exception at clause 60 says, a court hearing proceedings in private shall, on application of a party to the proceedings, give directions as to whether any, and if so, what information relating to the proceedings may be published. The bill itself specifically says that where it is of an important matter, a national interest, an international interest, that it will also consider publication of proceedings, hearing from the parties nonetheless as to whether they wish their business, quote-unquote, to be in the public domain. But, Madam Speaker, the hallmark of the generation of business is one thing. There is merit in the point that state enterprises, state companies, etc., need to be subjected to scrutiny. But I want to remind that this law binds the state. This law does not seek to accept the Freedom of Information Act. This law does not seek to accept any form of disclosure that is otherwise lawfully permitted, including under the Public Procurement and Disposal of Public Property Act. So there is an alternative remedy for information to be made known, but we cannot throw the trade marker out as a baby with the bathwater, Madam Speaker. Madam Speaker, the structures surrounding ouster, therefore, do not exist. We do have those provisions of the Freedom of Information Act, the Public Procurement Act, the Public Accounts, the State Enterprises Manuals, etc., Madam Speaker, and they are tied into our objects. Madam Speaker, we can demonstrate that in the course of consultation, we specifically, and for the benefit of interpretation that may come later in looking at these Hansard proceedings, I'd like to say for the record that the Trinidad and Tobago Bill 2023, having had a bill drafted since 2019 in a different form, took into effect the British Virgin Islands Arbitration Act 2013, the Barbados International Commercial Arbitration Act 2007, and the Jamaican Arbitration Act 2017, apart from the UNCITRAL model and the CARICOM impact model, Madam Speaker. Madam Speaker, the provisions are laced with due process. They're well and properly set out. The confining of limitation of appeal to our Supreme Court brings for certainty, as Minister of Finance put onto the record, that's not uncommon to our laws. You can look to our election petitions, etc. Madam Speaker, this law says that Trinidad and Tobago is open for business. I would like, as I end, Madam Speaker, to say a particular thank you to the drafting department at the process review team headed by Ms. Nirana Parsan for the time that I worked with her, and Ms. Varuna Chatu prior to her incarnation in 2018 in ensuring that this came together. It is tied to a concept of a civil division and to the ease of doing business in Trinidad and Tobago. I wish to compliment the Honourable Attorney General in bringing this home. For the record, Madam Speaker, I disclose that my wife's firm is engaged in aspects of arbitration where one of the partners are a certified arbitrator. So I put that onto the record. I myself have a master's in alternative dispute resolution, and I've spent a significant amount of time in this arena and in commercial law. I'm a huge fan of this law, and I believe, Madam Speaker, that this will bring benefit for Trinidad and Tobago. As we come to the celebration of the Treaty of Chaguaramas, as we come closer to a single market, we come back to 1939. In 1939, there were trade embargoes, there were difficulties. In CARICOM, our food importation bill was an issue then, it is now. In having commercial arbitration, in part of this structure, Madam Speaker, we bring to life the mechanisms of COTED and of CARICOM, and we say that Trinidad and Tobago is open for business. I thank you, Madam Speaker.
Okay, so honourable members, I've noticed a development, and I just want to bring it to our attention. This had become settled practice, and it's to remind members with respect to Standing Order 48.5. A member shall be referred to in this House by reference to his constituency or to his official portfolio. Okay, so I just want to remind members. So to say minister name, minister title, and the name does not conform with the particular standing order. Okay, Attorney General.
Thank you very much, Madam Speaker. Madam Speaker, the contributions which have followed my opening the debate on this bill, I pay tribute to all of them. I think that they have been significant, and I in particular want to acknowledge some of the remarks that have supported the acclamation of this important piece of legislation, that we are committed to passing this evening. I'm particularly, and I say this even though I have a smile on my face and I will allow myself a light tease, I am particularly pleased by the support, the fulsome and enthusiastic support of the Honourable Member for Diego Martin East. In particular, his acclamation of the fact that this legislation that we are hoping to pass this evening is significant in terms of the culture of alternative dispute resolution, the culture that we already embrace in this country as a mediation center, which we are continuing to build on. He has pointed me to some of the legislation out of the United Kingdom with respect to the adjudication center legislation, which I am going to put on my legislative agenda to come to the Parliament with in the new term. And there is this tease that I will allow myself, while I endorse the support of the member, to articulate, and it is that he spoke of expedition, which is one of the hallmarks of this particular piece of legislation. It is identified in the objects of the bill, and it is identified throughout. And in speaking of expedition, I just want to reassure the honourable member of the fact that he will appreciate, because this is something that I've had a conversation with him on, he will appreciate the huge significance in terms of protracted litigation to resolve commercial disputes. He will appreciate the huge significance of Section 56, subsection 3 of the bill before this House, Clause 56, 3, which says, and I read it in its entirety for the record, fees charged and expenses incurred by any arbitrator or foreign representative in an international arbitration which lasts for a continuous period of 30 days or less in a period of 365 days shall be exempt from income tax and any other tax of Trinidad and Tobago. The significance of that clause in this passage, in this bill that we are about to pass into law, is that it gives a very real incentive to the most important players in the arbitration process to bring home the results of the dispute resolution in a period of 30 days or less. That is a significant incentive in a culture in which we have become accustomed to litigation, laboring through years of unresolved disputes. The idea that we are passing legislation now and giving a reward to persons who are going to function expeditiously and bring home the result of the litigation, the arbitration, in a period of 30 days or less in a calendar year of 365 days, I think bodes well for the quality of expedition that this legislation is going to bring to bear. Of course, he has made the point that there are precedents that we will have to continue to look at. There's a precedent out of Jamaica, there's a precedent out of the BVI, and we will have to continue to look at that as we tweak the legislation going forward. But I think we are making a very significant start with that first incentive to bring home the results in 30 days or less. I also want to pay particular tribute to the Honourable Member for Port of Spain North, who speaks from the authority of the portfolio that he holds as Minister of Energy and Energy Industries. Because in my pilot today, both here and in the other place, one of the areas that I identified as being an area of high specialization, particularly germane to Trinidad and Tobago and the historical growth and richness of our economy, is that we have always been, for as long as we can recall in our youthful memory, we have always been an energy-based industry, an energy-based economy. And therefore, the fact that we can now put onto our books, our law books, legislation that is going to enable us to offer to the investment sector in Trinidad and Tobago, from outside of Trinidad and Tobago, the fact that we have brought ourselves up to the 21st century in terms of our arbitral platform is significant. So I was very pleased to be able to have as one of our colleagues on the bench today on the government side, the Minister of Energy and Energy Industries, who was able to speak, and the figures that he's put on the table, a $9.2 billion US dollar direct foreign investment in gas upstream. That gives us a tangible example of the value of this piece of legislation that we are looking to pass this evening in terms of alternative dispute resolution in the name of arbitration. And he spoke also with authority, and this crosses over to a point made by the member for Chaguanas West, the importance of confidentiality. The member for Chaguanas West spoke to it as well. The importance of confidentiality in the energy sector. It is not that the government of Trinidad and Tobago is looking to hide secrets or to have secrets or to hide anything from the population. But when you're out there in the real world and you are dealing with international players and they are sensitive to the direct international competition that they have to engage in, confidentiality is an important, very important litmus test in the capacity of international investors to be able to come to your country and to say, we can confidently do business with you because our trade secrets and other confidential information will be protected. And therefore, if in a dispute resolution process, we can promise them with our UNCITRAL-based legislation, the Arbitration Act of 2023, which is what this act will be called when this evening I hope we pass it into law, we will be able to say with confidence to potential foreign investors, your confidentiality will be respected, not by way of keeping secrets from the citizens of this country, but by enriching them for the future lives of their children and their children's children. So I'm grateful for the support that I've had from my colleagues on the government side, and of course, I acknowledge the contributions from the member for San Fernando West, Honorable Al-Rawi, who is the predecessor in the office which I now have the privilege to serve in, and I acknowledge and I thank him for the considerable work that he's done to enable me this evening to bring this bill before this House, and I particularly wish to associate myself with the recognition that he's given publicly to the names that he's called, Mr. Dennis Gurley, Senior Counsel, and Salma Rahman, who have made invaluable contributions. And of course, it would be remiss of me if I did not, and I will come to that name in a little while. It will be remiss of me if I did not acknowledge one other name, but I will get there in due course. Madam Speaker, I also want to acknowledge the contributions of the Honourable Member for Mearu. He made some significant, in my view, contributions in terms of the acknowledgement and the support that I understood him to have uttered in response to this bill that is before us. There are aspects of his contribution, of course, which I don't share, but that is not to take away from the areas in which I am grateful for the support. So for instance, the fact that he was able to speak to the desirability of specialized commercial courts, that is something that this government is working towards, because the entire, and when I was speaking earlier today on the other efforts that this government is making in other areas of the improvements in the justice system, we are committed to not only in that other area that I was speaking to earlier, improving our criminal justice system, but also our civil justice system. so that it is entirely compatible with the arbitration bill that we have before the House this evening, that in due course we will be looking to come back to this country and to the citizens of this country to speak to strides that are expected in terms of developing specialized commercial courts. The honorable member for Miaro also made an interesting comment in relation to CARICOM and the revised Treaty of Chaguaramas. And I acknowledge the contribution in that regard as well of the member for San Fernando West, my good friend, the honorable member for San Fernando West, who made an interesting tribute, which is very apt, and I'm grateful to him for reminding me that next week we are celebrating the 50th anniversary of CARICOM. And that takes me back to the comment made by the honorable member for Miaro, who spoke to the possibility that perhaps, and I hope I don't misquote him, that perhaps we could look to addressing the CARICOM revised treaty to enable us to get into more arbitration. Well, the reality is, as we celebrate the 50th anniversary of CARICOM next week, that Chapter 9, Dispute Settlement, Article 223 of the CARICOM revised Treaty of Chaguaramas, signed right here in Trinidad and Tobago, states at 223, sub-article 2, each member state, with your leave, Madam Speaker, I quote, each member state shall provide appropriate procedures in its legislation to ensure observance of agreements to arbitrate and for the recognition and enforcement of arbitral awards in such disputes. So our revised Treaty of Chaguaramas, signed right here in Trinidad, which gave birth to CARICOM, celebrating appropriately its 50th anniversary next week, has always invoked for us, the citizens of CARICOM, the step that we are taking today to bring this revised UNCITRAL model law onto our law books, consistent with, as I said in my pilot, the desire, the dream, and the vision of the late Honorable Prime Minister Patrick Manning. So I acknowledge that. And if I may then come to one final point in my wind-up, Madam Speaker, and it is to acknowledge the remarkable resourcefulness, and I say this almost every time I stand here to speak to the legislation that I have the privilege to pilot, the resourcefulness of the team out of the Office of the Attorney General and Ministry of Legal Affairs that I have the privilege to lead. And I got from that lady, that very lady that Honorable San Fernando West member mentioned, Ms. Nirana Parsan, and a WhatsApp, literally as I was sitting here, that provided me with some material that I am going to close with. Ms. Parsan is head of process review. She has been the one who has been leading the work that has supported me in bringing this bill to the Parliament, of course, ably assisted and supported by the Chief Parliamentary Counsel's department. I received from her at about 6 p.m., 7 p.m. this evening, an article, a blog, dated April 2022, Thomson Reuters Practical Law Arbitration blog by Akima Paul Lambert, partner in Hogan Lovells. And I hope you will forgive me, Madam Speaker, and my friends will forgive me if I quote at some length from this article, because it is so apt. April 2022, it is so apt to everything that we are saying here today, and is a recognition from outside of Trinidad and Tobago of the ethos and the purpose of what we are about here. So the article begins with a reference to a previous article written in 1994, in which that previous article had highlighted the limited success of commercial arbitration in the commercial region. And then the article says, the causes of these early failures, and I quote, Madam Speaker, the causes of these early failures, that is to say, the failure of the Caribbean community to take advantage of arbitration, were attributed to a combination of cultural apathy in the concept of arbitration. It appeared as if Caribbean citizens wanted their quote-unquote day in court, general resistance to the harmonization of arbitration legislation, and perceived disinterest by the business community. And then it continues. However, recent developments, again I quote, recent developments demonstrate that dispute resolution services in the Caribbean region are demanding faster and more flexible mechanisms to resolve their disputes. A renaissance for international arbitration in the Caribbean is on its way. There have been recent efforts by stakeholders to encourage the growth of arbitration in the region, and the article cites the CARICOM impact justice work that I have cited in my pilot and is cited throughout the work of the bill that is before the Parliament today, because it is modeled off of that bill, is modeled off of the CARICOM justice impacts model law on the UNCITRAL law. And the article says the impact of this, that is to say, the recent efforts by stakeholders, the impact of this cannot be overstated. And I quote last this paragraph, so pertinent to what the Minister of Energy and Energy Resources was saying earlier. Recent changes and potential transformations in the energy sector are also likely to have an impact on the choice of dispute resolution. The Caribbean has already seen a spate of international investment disputes, notably in the energy sector, and we are likely to see more. Guyana is mentioned, and then it concludes, also, the impact of alternative energy transitions should not be understated. The Caribbean is heavily impacted by climate change and is poised to be the beneficiary of climate mitigation funding. If disputes arise in relation to the implementation of any transactions relating to climate or alternative energy, parties will look for a dispute resolution process that is efficient, location neutral, and where parties have influence over the composition of the tribunal. Madam Speaker, that is an April 2022 article speaking to the very business that we are about in this House today and recognizing the sea change that has occurred in the Caribbean, which Trinidad and Tobago is now committing to in the very piece of legislation that we ask you to, I ask my colleagues in this House to join with me on in order to pass this into law. With the greatest of respect, Madam Speaker, I beg to move.
Honourable members, the question is that a bill entitled An Act to Repeal and Replace the Arbitration Act, Chapter 501, to provide a modern legal framework to facilitate domestic and international trade and commerce by encouraging the use of arbitration as a means of resolving disputes and for related matters, be now read a second time. All in favour say aye. Aye. Any against? The ayes have it.
A bill entitled An Act to Repeal and Replace the Arbitration Act, Chapter 501, to provide a modern legal framework to facilitate domestic and international trade and commerce by encouraging the use of arbitration as a means of resolving disputes and for related matters.
The Attorney General.
Madam Speaker, in accordance with Standing Order 68-1, I beg to move that the Arbitration Bill 2023 be committed to the Committee of the Whole to be considered clause by clause.
Honourable members, the question is that the Arbitration Bill 2023 be committed to the Committee of the Whole to be considered clause by clause. All in favour say aye. Aye. Any against? The ayes have it. This House will now go into the Committee of the Whole to consider the bill clause by clause. This bill has 66 clauses. AG had no amendments. Any amendments? Okay, so can we agree to do this in parts?
Clauses 1 to 9.
The question is that clauses 1 to 9 stand part of the bill. The question is that clauses 1 to 9 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clauses 1 to 9 now stand part of the bill.
Clauses 10 to 12.
The question is that clauses 10 to 12 stand part of the bill. The question is that clauses 10 to 12 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clauses 10 to 12 now stand part of the bill.
Clauses 13 to 18.
The question is that clauses 13 to 18 stand part of the bill. The question is that clauses 13 to 18 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clauses 13 to 18 now stand part of the bill.
Clause 19.
The question is that clause 19 stand part of the bill. The question is that clause 19 now stands part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 19 now stands part of the bill.
Clauses 20 to 30.
The question is that clauses 20 to 30 stand part of the bill. The question is that clauses 20 to 30 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clauses 20 to 30 now stand part of the bill.
Clauses 31 to 43.
The question is that clauses 31 to 43 stand part of the bill. The question is that clauses 31 to 43 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clauses 31 to 43 now stand part of the bill.
Clauses 44 to 52.
The question is that clauses 44 to 52 stand part of the bill. The question is that clauses 44 to 52 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clauses 44 to 52 now stand part of the bill.
Clause 53.
The question is that clause 53 stand part of the bill. The question is that clause 53 now stands part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 53 now stands part of the bill.
Clauses 54 to 55.
The question is that clauses 54 to 55 stand part of the bill. The question is that clauses 54 to 55 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clauses 54 to 55 now stand part of the bill.
Clauses 56 to 66.
The question is that clauses 56 to 66 stand part of the bill. The question is that clauses 56 to 66 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clauses 56 to 66 now stand part of the bill. Honourable members, the question is that the bill be now reported to the House. Those in favor say aye. Aye. Those against say no. I think the ayes have it. This committee meeting is now adjourned. The House will resume. The Attorney General.
Thank you, Madam Speaker. I wish to report that the Arbitration Bill 2023 was considered in the Committee of the Whole and approved without amendments. I now beg to move that the House agree with the committee's report.
Honourable members, the question is that this House agree with the committee's report on the Arbitration Bill 2023. All in favour say aye. Aye. Any against? The ayes have it. The Attorney General.
Madam Speaker, I beg to move that a bill entitled An Act to Repeal and Replace the Arbitration Act, Chapter 5, Number 1, to provide a modern legal framework to facilitate domestic and international trade and commerce by encouraging the use of arbitration as a means of resolving disputes and for related matters, be now read a third time and passed.
Honourable members, the question is that a bill entitled An Act to Repeal and Replace the Arbitration Act, Chapter 501, to provide a modern legal framework to facilitate domestic and international trade and commerce by encouraging the use of arbitration as a means of resolving disputes and for related matters be now read a third time and passed. All in favour say aye. Aye. Any against? The ayes have it.
A bill entitled An Act to Repeal and Replace the Arbitration Act, Chapter 501, to provide a modern legal framework to facilitate domestic and international trade and commerce by encouraging the use of arbitration as a means of resolving disputes and for related matters.
The Leader of the House.
Thank you very kindly, Madam Speaker. Madam Speaker, I beg to move that the House now adjourn to a date to be fixed.
Honourable members, there are two matters that qualify to be raised on the motion for the adjournment. I've been told that those matters are being deferred. Whip. Well, I only see applause on one side, but Whip, you are the one to confirm that I'm correct. Honourable members, the question is that this House do now adjourn to a date to be fixed. All in favour say aye. Aye. Any against? I think the ayes have it. This House is now adjourned to a date to be fixed.